mentioning on that side matter. Item number 9. My brother is sick, my lord. Just now, my lord, I am over telephone. I inform. I am leaving the court, my lord.
Not today.
Item number 9. I am 1 minute. 1 minute. Lordship. My lord, I am praying for the my lord, 2 weeks time, your lordship, kindly. Because
2 weeks time. Who is the other side?
No, I am for the other side, my lord.
There is some difficulties.
difficulty, my lord. That's why I am leaving, my lord. My brother is sick, but now he is hospitalized.
Yes, appellate side.
Well, first week of May, because before election, well, there is something, my lord. First week of May, your
CEO.
lord, kindly understand.
Let the CEO number show.
After
listed.
election.
Listed. No. 23rd.
On 27th of 23rd of March to this year. Your lordship, difficulties, your lordship, all the names have not been recorded in proper form and one name has come in short, like the full name is not there. So lordship, I'm just, if that can be corrected, your lordship, giving judgment, only that appearances, your lordship, for petitioners, your lordship.
Incorrect or
some name is missing, one name has been recorded, like my name.
whatever you have name given, that was mentioned.
Your lordship, I have my
earlier order also.
your lordship, on the last day of the when the judgment was being declared by your lordship on the open court.
That day nobody was there.
Your lordship, I was there on behalf of the
You
petition.
are there.
No, I had given the appearances once again on that same day itself also, your lordship, in the same order. I am
Conclusion.
Yes.
Wait for some time because there are a lot of matter listing.
There is the order, my lord. I attest the order. Like, there is a specific direction for the filing of affidavit in opposition, but the respondent agrees the seal date. Well,
Not filed.
not filed, my lord. And direction, my lord, for liberty to mention, my lord.
Which year?
2024.
24. You wait some time.
extension of interim order. Extension of
Yes or no?
I am for the petitioner, my lord. I am for the alleged contempt. My lord, in terms of my lord's previous order, my lord, we have received 2 affidavits. My lord, here there are 5 contemners, and insofar as contempt is concerned, my lord knows that contempt is an action against in respect of each contemners. My lord, they have filed 2 affidavits only, and
there are
5,
2, 3, 4 alleged contemners.
my lord, 5, my lord, according to me, 5.
And who is appearing for 5? Oh yes, 5 is also there. Yes.
I am up there. But my lord, the affidavits that they have filed, they are not in proper form. Each contemner ought to have filed their respective affidavits. It cannot be so that someone else affirms an affidavit on behalf of a different contemner altogether.
Let them take their objection. This is the
No, what objection you are filing?
in terms of my lord's directions, we have filed our affidavits. We are yet to file it. We've served.
So alleged contemner should be filed.
My lord.
We have.
My lord.
It is our prerogative, my lord. 3 of them have filed, the same affidavit.
So I will issue rule against other 2.
No.
Let them file. Come and file.
Each of the contemners, have filed.
Each of all 5
contemners? Yes, my lord. 3 contemners have filed it.
Join.
Indeed, man.
And who has affidavit? Make affidavit.
The contemner number 1 was a company.
So what is your contention in your objection? You have not. You have complied the order.
We have come. There has been no allegation of contempt at all. But if the contempt petition is taken, there is no case of contempt made out. This is a contempt petition which has named the shareholders of a subsidiary in which India Media has shareholding as a contemner. It has named the advocate on record of India Media as a contemner.
If they violate the
Not-
court order, why not they will be
There is no question of violation.
implicated as a alleged contemner?
May I say this, the deed has already been conveyed. That is before my lord.
That may be,
is-
but if
Milord-
if you violate the court order,
Yes.
you will be liable for contempt.
There was no scope of me violating it. There was
You
no
are saying
scope
you
of
have
me
not
violating.
violated.
May I just point this out?
So far as I remember, you have given a letter to the registrar and asked him not to register.
No,
The deed.
may I say this? May I say this?
So far as I remember,
No,
I
this
do
was
not know. This is the allegation.
My lord may take that letter. Nowhere in that letter was it stated that the registrar may stop, the registrar
So I
original
will
side of the
hear
Calcutta High Court.
let
I have everything is on record here.
let him place his case thereafter.
Milord,
Yes, I will take up this.
I've in terms of my lord's order, I filed the affidavits. All my lord responses
My
are
lord, this is my lord, since this is a matter,
Go through the responses.
my lord, I have received a copy, my lord. My lord, may I only indicate this? My lord, since this is a contempt proceedings, in a contempt proceedings, there cannot be joint affidavits. They have been made party as contemners. Each contemner ought to file their own respective
Actually,
affidavit.
I have allowed them to file objection only to
prior to the route.
state
Yes.
My lord,
they
they're
have
compliant.
complies or
My lord.
not, or whether they have violated or not.
My lord,
To ascertain their view.
my lord, my lord, there.
Now, content between the contemner and the court.
Indeed, my lord. My lord, the second point is that my lord will see that they have filed. This is not their compliance report that they have whether they have complied or not. That has not been stated.
No,
This is an affidavit in
They have
opposition.
violated, then question of compliance report is required.
My lord.
They were not the party
Milord,
in the proceeding.
I am grateful.
Number one, they were outsider.
I am grateful.
My lord, they are the directors. They are
They
two
are
of
the
them are the
directors.
directors.
How many directors were there?
Two persons were the directors.
Huh?
One of them was the advocate on record who was representing.
Whether
and-
they were aware about the order of the
Yes,
Milord,
it's a
kindly
firm.
note
It's a
this is what
firm.
has happened.
It is their letter, my lord. Their signatures.
active director or
Milord, in 80,
Milord,
90-year-old, I'm sorry, 90-year-old lady has been, named as an alleged contemner without a single pleading to show what contempt.
now
he
I
has done.
think your purpose has been
My
solved.
lord. My lord, what has been happening?
Has, Milord.
There is more.
Your deed has been registered.
No, my lord, there has been further acts of contempt. Even after this, although my lords, the order has been complied with, there has been injunctions which has been passed by my lord's order of 24th September. Even there has been violation of those orders as well. My lord, I shall be filing a response to this if my lord permits, because
Would you like to file?
yes, my lord, I will have to, my lord. That is why I want to bring that on record. Second, my lord, I wanted to point out that if my lord permits this affidavit to be taken on record, I do not come in the way. But for contemners, my lord, they had to file their own each respective affidavits because it's a personal action. Because they have filed it jointly, I wanted to point it out to my lord. And my lord will kindly grant me time. I will file my affidavit and come back to bring on record what all additional incidents have happened.
Milord, perhaps my learned friend is talking about a
Okay,
situation where a
two
rule is given.
affidavit, two
That's not the situation.
IDPR affidavit,
হ্যাঁ।
দুজনের joint affidavit
Yes,
করে
joint affidavit not possible.
আমি কিন্তু my lord allow করছি বলছি কারণ compliance দেখার জন্য
You file exception, I will hear you. But these are not so important. If they violated, then I will issue rule
Yes, it is technical. I agree.
because they were not the party in the suit, in the proceeding.
Yes.
They were outsider, whether they were aware about the judgment or not.
Milord,
That is a question one, whether they have violated or not. Already did executed in view of my order.
yes.
Now I will see whether they have violated order or not.
Anyway, if they join jointly, they will all come. When
Yes,
your
yes.
lordship issues
Definitely,
rule.
if I will issue
Yes.
rule, they bound to come.
Yes.
If they want to drag an 85-year-old lady with nothing to do with something. This is the
I will see.
object.
I will see. He wants to file exception. Otherwise, I would have hear you.
Yes, if they will file a reply, then rule can be issued.
Exception, not reply.
my lord is not allowed. আর item number 2 টা আছে their review application.
No, 2 Milord is their review application.
And let me keep it on the same day, my lord.
Why you are dragging this matter review without any grounds?
My lord, the grounds.
100 grounds.
My lord, the grounds will not.
Maybe 1,000 grounds.
My lord, we'll
Review
endeavor to
require
justify-
only 3-4 grounds.
My lord, we'll endeavor to justify, my lord. Let me keep it on the.
100 of judgments I have dealt. More than 100 of judgments.
Milord, it is not possible that any judgment can give 100 grounds of review.
Why should I take all the judgment referred by the advocates if there is not at all relevant?
My lord, we'll
Number
make a
one.
submission in that regard. My lord, we'll do.
If I cite 5 judgments on one point, and your lordship, Milord, deals with one of the first of the 5 and says this is inapplicable, no need to cite the other
Even
4.
if I do not consider the judgment, that is the ground for review.
No.
My lord, we'll make submission in that
But
regard.
your lordship has considered all of them.
Even for the sake of argument, if you have referred 10 judgments, I only considered 2 judgments. I did not consider 8.
That's not a ground for review.
If you agreed, there is a provision for appeal.
My lord, if I may submit, my lord, if an argument are submission, if an argument that my lord, perhaps not been
Just I am
My lord will not take me amiss. It's a justifiable review. We'll try to, we'll endeavor to.
just he said that 100 grounds has been taken by you. That's why I am giving you. When you
Actually, huh?
when you will want.
My lord, we keep it along with the contempt on the same day.
So on the prayer of learned counsel appearing on behalf of the petitioner.
Very well. Great.
What about appeal? Appeal has been preferred. No.
My lord, in terms of.
Appeal has not been preferred as yet.
They have filed at least 10 litigations, but not an appeal.
No appeal has been filed.
Come in the way of our.
No.
Occupation.
No, I am grateful. I have got 10 briefs because you have filed 10 petitions. If you had filed 1 appeal, I would have got 1 brief.
My lord, in as much as my lord is disposed of the 34, my lord,
Advocates are benefited.
Fine.
Okay.
I'm grateful.
Lordship, may permitted to mention one matter for extension of interim order.
What?
For extension of interim order already expired, Lordship, but file within kindly tomorrow or day after tomorrow maybe.
No, I cannot say because
Much of it.
it will appear in the list.
To add for the respondent, this matter has been come in the list for having back the original case records, my lord. The original case records, this matter has been disposed of on March 27th of March 2026, my lord. But pursuant to the order of 15th May 2025,
Oh, you want take back some
original case
documents.
record, my lords, that has been submitted in a sealed envelope
Okay.
This is the order.
When you have submitted?
This is the order, Lordship, pursuant to which I have submitted the case records.
देखो, this matter.
Lordship, DN raised in this matter. DN raised in this matter. Or perhaps the judgment passed in the last day.
Yes.
Recorded
Uh,
judgment passed on the last day. Record the name recorded was DNROY. It shall be RAY, Senior Advocate for the Union of India.
D.N. Roy. In place of D.N.
RAY.
Roy, what would be the actual name?
DNRAY, Senior Advocate.
R.A.Y.
Grateful.
This instant matter appeared to be appeared as Daku.
2 p.m. Peak matter item number 269.
May it please your Lordship, I don't know. I don't see the other side at all.
Why other side is not there? It was fixed in their presence.
Yes, of course.
The matter has been fixed in their presence.
Yes, my lord.
Time is also fixed.
But I made my, I was making my submissions on this, my lord. And just give your lordship the background, remind your lordship, my lord, what happened. Because it's quite sometimes past, my lord, since your lordship.
I have remember all
Your-
the
your lordship
submissions you have already, most
Well,
submissions has been made.
So, my lord, your lordship remembers, my lord, exactly.
Yes,
So,
yes, this is
my lord, may I then
influence, yes.
start from where I left off?
Mm.
Well, my submission is this: your lordship is pleased to see that when this, I mean, the relationship between the parties was going on, my lord, a show cause notice was issued. We replied to the show cause notice, and thereafter, my lord, this impugned letter was issued without any reason at all. This your lordship will be pleased to find. Kindly come to page of the writ petition, my lord. Kindly come to the impugned letters. Can you give me 1 second?
65.
Yes. This is at page. Kindly first come to the letter at page. এটা বার করে দেখো না কোথায় আছে।
You have given reply to the insurance,
Yes.
the executive director, insurance regulatory on 28/10/2024, 2004.
কিচ্ছু পড়তে পারছি না আমি এটা। My lord, would be pleased to come to page 72.
72. Yes.
This is a letter, my lord, issued by them.
After receiving your reply.
Yes, my lord. This is a letter by which, my lord, I am not troubling your lordship with the entirety of it. I have placed it before your lordship. Kindly come to page 73. By this letter, the National Insurance Company is writing to us saying that we have been advised not to accept any business from you through any arrangements like agency, memorandum of understanding, or reference, or by any other name. In the above circumstances, the said two memorandum of understanding dated so and so are hereby stand cancelled. Now, my lord, kindly come to page 74. We have said that if you have.
So they have not cancelled your insurance policy. They have cancelled the memorandum of understanding. Only.
Yes. And my lord, in the memorandum of understanding, if your lordship sees, our grievance is this, that if very well, you have cancelled it, you have cancelled it. But this amount of money that you have taken from me, kindly come to page 40. This is the memorandum of understanding.
That security deposit you want to refund back.
Yes, I said that. Kindly note the language. A general deposit of rupees.
Which page you are reading?
Is, my lord, I am reading at page 40.
40.
40. This is, my lord, a part of the memorandum of understanding. Clause 15 of the memorandum.
Yes.
A general deposit of rupees 50 lakhs is always to be maintained by Golden Multi-Service Club Limited with NIC so and so of Calcutta till the expiry of MOU between so and so. No interest shall be payable on the deposited amount. The so and so will have the right to adjust his deposit amount for any financial default by my client, GMSSC.
They have not given any information that whether you have defaulted or any of the.
That's right. On the contrary, my lord, they have just appropriated the amount of money, and my lord, they are not refunding, even though, my lord, we are claiming them back. I said that you have terminated, refund me my money. Unless you show that there is some financial default, it cannot be returned. So, my lord,
after that, what they have given any reply?
Yeah, my lord,
I think 50 and 51 crore you have demanded.
Yes, my lord, because
two amounts,
50 lakhs, plus, my lord, 41 lakhs of rupees, my lord, was taken by way of advance. Even that, my lord, is not being refunded. Your lordship will please to come to
page 55.
In the two memorandum of understanding, the similar clause, your lordship has seen.
No, I have seen.
Yes, no. There are two clauses. So, my lord, I am not troubling your lordship with
whether any letter was given to them to refund the money.
Yes.
How much money you are asked to refund?
Kindly, my lord, come to page 74.
74, yes.
After they have given the letter at page 72,
So aggregate 1 crore you have asked for refund.
yes, this is the my lord 50
Not
lakhs.
41.
41 lakhs, my lord, that we have claimed in a separate letter. 75. At page 75, if your lordship kindly comes.
So that is also asked for return.
Yes.
That is security deposit.
41 lakhs 45,000. The last sentence in for the first paragraph.
After that, they have not replied.
No, no.
Not
What they
replied,
have
not
done is that,
refunded.
what they have done is this, my lord. My lord, if I may use the expression, Mahabharata has been written in the affidavit in opposition, giving, my lord, a lot of things, saying a lot of things, my lord, which are not there on record at all. In the affidavit in opposition, they are seeking to justify their my lord, forfeiture by giving, my lord, a lot of explanations. If your lordship kindly take the affidavit in opposition. I'm not going to trouble your lordship with this. I'm sure my learned friend will explain, my lord, what all these are said. But my lord, your lordship kindly comes to paragraph 9 at page 23. I'm not troubling your lordship with the entirety of it. There are a lot of stories have been spun out. Paragraph 6 at page 23. Para 9. Para 9 at page 23. With reference to the allegation, your lordship got, sorry, ma'am. Paragraph 9 at page 23.
There is no opposition, only reply is available.
তোমাদের অপোজিশনটা রয়েছে তো রেকর্ডে দেখো দেখো আমাদের রিপ্লাই দিয়েছি পিটিশন দিয়েছি তোমাদের অপোজিশন দেখে দেখো দর্শক খুঁজে পাচ্ছি
Did you file the opposition?
And it was served upon us. But the file was not 2008, my lord.
Original copy. Did you file when you have filed?
My lord,
তোমাদের রিটার্ন নেই ওখানে
order of reflection. My lord, Popon Shane was the recorded advocate at that point. I have come into the brief only 23, my lord.
Maybe, but original copy
Yes, Tapun Kumar
not lying with the
Tapun Kumar.
record. Nahi.
There is order of reflect করছে না যে কবে ফাইল করেছে
When did you file?
My lord, as per my records, my lord, it was filed on 15th of September 2008. Served on 15th of September. No, filed on the same.
Do you have copy? Extra copy?
I have a copy, but it's a marked copy.
তো ফ্রেশ কপি নেই একবার জুনিয়র কি লিখতে নেই না তোমার কাছে তোমারটাও মার্ক
I have only one copy with me now, but my lord, I can give copy.
My lord, we have got two marked copies, one by the respondent, one by the petitioner. I think, my lord, if it is marked copy, petitioner's copy will be a better. Well, it's quite a thick volume, my lord. I don't know.
Unmarked copy পেয়ে গেছে একটা।
পেয়েছি।
ফাইল টাইল করেনি তার মানে সার্ভিস করে রেখে দিয়েছি।
And this was recorded,
I have got
recorded in order on 25th September 2023 that no copy of affidavit in opposition is on record.
They only served it.
I do not think that I must be.
Though the affidavit has been exchanged between the parties.
Yeah, between the party.
Grants me an opportunity to take the necessary steps and correct the records, my lord.
Do you file one copy?
My lord, I shall do. Grants me a limited opportunity, I shall do that, my lord.
So you complete your argument.
Yes. Well, may I then hand up to you also a copy which I shall take back. In the meantime, my little friend, but I'm sorry, my lord, this is a rather an old copy.
No problem.
I also apologize.
This is the old matter. What can we do?
Paradigm.
Sarah 9, yes.
Page 23.
Page 23. With reference to the allegations made in paragraph 10 of the petition, it is denied that the insurance company became liable to refund or return rupees 50 lakhs each, as mentioned in the two MOUs totaling rupees 1 crore or any other sum, as alleged inter alia, for the reason that the writ petitioner caused huge loss to insurance company by violating the terms and conditions of the MOU. Kindly note these words. Irregularities were found in the underwriting practice of the writ petitioner. In terms of the said MOU, the respondent number 1 issued the policies bona fide to the writ petitioner company with the understanding that the benefits would be given to its club members subject to the condition with the risk experience as per the terms and conditions, guidelines, and circulars issued by the insurance company from time to time. However, it was found only at the time of settlement of the purported claims that the petitioner made breaches by adopting inter alia. 1. Its members were granted certificates under GPA without considering social status and their income, and violating guidelines of MOU under which the policies were issued. Then 2. Submission of incomplete proposal forms without details of the income age address, and thereafter inserting the information subsequently. Then 3. Under the two MOU, both dated 2nd April 2004, it was mandatory that claims would not be entertained if they are not intimated within the stipulated time by the claimants, and thereafter, if these are not submitted by the writ petitioner within the stipulated time. There were also other serious breach of the conditions. As repudiation of claims on various grounds, the respondent number 1 could ascertain that the conditions of the MOU had been deliberately flouted and or ignored by the writ petitioner. Repudiation letter and claim intimation letter against claim number so and so, which violate the conditions of MOU and had deliberately flouted and or ignored by the writ petitioner, are annexed here to and marked R6. Your Lordship will please to come to the annexure R6. This Your Lordship please to find at page 94.
Yes.
Mandatory no.
Your Lordship kindly comes to this is 1st July 2008. Address to Mr. Mukundulal Sarkar, Advocate. Dear Sir, JPA claim number so and so. Kindly see, my lord, this is being written to one of the policy holders. On examining the above claim,
Mukundulal Sarkar is the advocate.
Yeah,
The policy holder.
of the policy holder.
Policy
Of the
holder.
policy holder. My lord, I think, my lord, what happened was this: Mr. Mukundulal Sarkar, as the advocate of one of the beneficiaries, had written a letter claiming certain amount of money, and this letter is replied to that by the respondent. It says, on examining the claim file, it is noticed that the above claim had been repudiated by our letter dated so and so, since the insured had intimated and submitted the claim on 16/3/2006 and 30/6/2006 after a gap of 22 months, 16 days from the date of date of loss. A copy of the letter is enclosed for your ready reference. We would like to inform you that as per the terms of the policy and condition enumerated on the back side of the certificate provided to the insured, condition number 1, the claim was inadmissible on the ground of limitation. Well, the insurance company on the ground of limitation is seeking to dispute the claim addressed to the insured. Under the circumstances cited above, please also be noted that the above claim was not entertainable due to claimant had failed to comply with the terms and conditions of the contract of insurance laid down by MOU agreement between the so and so. For your kind information, we are mentioning the concerning part of the judgment of WP number so and so decided on so and so between so and so and etc. Then Honorable Mr. Justice Pinakshi Chandra Ghosh, the High Court of Calcutta, with jurisdiction, constitutional writ jurisdiction observed. Then heard the learned advocate for the respective parties. It is pointed out by Mr. that learned advocate appearing for the respondent number 2 to 4 that the petitioner has failed to comply with the conditions laid down in the policy and the petitioner filed this application on the basis of incorrect facts without disclosing terms and conditions. According to the petitioner is not entitled to get any benefit under the said policy. Then, my lord, it appears that the petitioner's husband was an insured policy named as Janata Personal Accident Policy with the respondent company. It further appears that the petitioner in the instant case has failed to comply with the terms of the contract of insurance laid down in the agreement between the insurance company and the insured. Furthermore, it appears in the petition itself that the petitioner did not disclose even the terms and conditions of insurance policy which ought to have been met by her in this application, which is also nothing but a suppression of material facts. And if the writ petition suffers from any suppression of material facts, the writ court should not entertain the application. It further appears, etc. Then, such being the position, I do not find any merit on the application, hence the application will dismiss. This is unquote. In view of the above, we are constrained to repudiate the above claim. So, my lord, it's an individual claim which has been repudiated. My lord, this has been cited at page 25 of the affidavit as a ground. Why, my lord, this amount which has been deposited. So, my lord, what is happening is this: that
every insurance policy should have considered separately.
Separately, yes. And then, my lord, you justify as to, with regard to repudiation of the claim on the basis of facts of each of these cases.
But how writ court can?
Yes, how this
enter
this is the
into-
point.
This is
Right.
the point.
Right. Now, nothing.
That is the point. How the writ court can consider which terms and conditions you have violated.
And my submission is very short. My submission is this: that the writ court has jurisdiction. I shall cite before your lordship the decisions. The writ court has jurisdiction to go into factual cases. The writ court is not interested, my lord, is not empowered to go into the disputed question of facts. But if it is found that any action of the respondent is arbitrary, unreasonable, without any reason, then the writ court, my lord, comes down with heavy hand, says that this you cannot do, because that will amount to, my lord, an arbitrary action on the part of the respondent. So I am, my lord, adverting to your lordship this point.
All those insurance policy was regarding medical claim.
Yes.
Number one. Whether any insurance policy was for life.
Well, really, well, if I may respectfully submit to you, sir, well, kindly look at it from this point of view. I have got a memorandum of understanding with them, written agreement between, my lord, the respondent and the petitioner, in pursuance of which, my lord, certain sum of money had been deposited by way of security deposit.
Individual insurance policy.
Individual insurance policies were issued in pursuance of that agreement.
How many insurance policy was
there will be said numerous. Well, I shall give you lordship. Well, the point is this, that in respect of each individual policy, you consider. In this particular case, for example,
so that amount is only for security, and if any money defaulted, that can be adjusted.
Adjusted.
That was the MOU.
That is the MOU. this has got nothing to do with, my lord, these individual policy claims, which, my lord, they are
When
entitled
MOU
either.
has been cancelled by the insurance company, they will only see whether any default was made or not.
Right,
And if some default was made, that should be adjusted with the
my lord.
security deposit or that amount which was without bearing interest.
Absolutely.
That would be the
That would be the position.
position.
my lord,
But
can
they
you-
have not
No,
given any
This is,
reply
my
or
lord,
any
no,
any
what they are-
ground that you have defaulted so and so
Exactly,
amount.
exactly. What they are doing is this, what they are citing before your lordship is this, that individual policyholder,
Whether any terms and condition in the memo of understanding that if any terms and condition violated, the money will be forfeited. Is there any?
no, there is this particular clause, your lordship has been pleased to see the clause. The clause is, if I may just come back to the clause once.
MOU, please come
Yes,
to the
yes, my lord, kindly
whether
come.
any
That
condition
particular,
that if any terms and condition violated by the insurer, then the entire amount would be forfeited.
I'm giving your lordship, my lord, kindly come back to page 50. Kindly come to page 40.
40 of the writ petition.
Yes.
Yes, 40.
Unless they can show that there had been any breach of any of the conditions of this policy, they cannot, my lord, invoke this particular clause. Kindly come back to the clause itself at page 40, bottom. A general deposit of rupees 50 lakhs is always to be maintained by Golden Multi-Services Club Limited with NIC till the expiry of the MOU. Till the expiry of the MOU between GMS Limited and NIC Limited. That is, my lord, my client and, my lord, the respondent. No interest shall be payable on the deposit amount. Insurer will have the right, kindly see, insurer, meaning thereby the respondent, will have the right to adjust this deposit amount for any financial default by the respondent, by the petitioner. So, my lord, they will have to show financial default on the part of the petitioner, not, my lord, individual policyholders. My lord, what indication had been given by them in their letter, my lord, and there, my lord, your lordship will have to consider the letter which they have written for the purpose of, my lord, forfeiting this amount of money.
Yes, that's why I'm asking you any terms and condition mentioned in the MOU.
No.
That if you default or if you violated any terms and condition, entire
This is
amount.
what it is. In a
That's
financial,
I have seen. That is paragraph.
that is all.
That is only a condition.
That is only nothing else is there.
Amount was deposited only for financial default.
Financial default. So what?
For adjustment of the financial default.
So therefore, they will have
if there is a default, suppose 50 crores, 50 lakhs, then they will return 50 lakhs.
Yes.
If 20 lakhs default,
they will deduct
20 lakhs
and
and
30
refund
lakhs.
80 lakhs.
Absolutely.
That is the MOU.
That is the MOU.
Apart from that, there is no any other clause that
and, my lord,
money will be forfeited if terms and condition will be violated.
Correct.
No terms and condition is available in the MOU.
At least, my lord, there is nothing has been shown.
In such a situation, writ court can exercise its power to direct the insurance company to refund
refund this amount of money.
That is your submission.
This is my submission. I'm very grateful to you. This is shortly my submission. And, my lord, kindly note that when they are forfeiting this amount of money, in that letter also they are not saying on what ground. Your lordship has been pleased to see that.
They have just.
Yes, your lordship has been pleased to see.
Specific, but
Just,
they have violated the condition and
yes, nothing has been said. And financial default.
They have cancelled your MOU. Okay, no problem.
Very well, cancelled. I don't mind.
Cancel insurance company.
Yes.
Will not continue any further.
I've got nothing to say to that.
But that deposit amount, that is only to adjust the default.
That's right. Financial default.
Financial default.
They will have to show that this is the loss I have suffered by reason of my default. And that then, my lord, they can adjust this amount of money. If they do not do that, then my lord, I
If they
respectfully
have suffered, they may file their suit or anything else, whatever.
or my lord, at least to say, at least to tell me when I am claiming back the money, and this is the act of arbitrariness. When I am saying that you have taken the money from me, and this is not a small amount of money, 50 lakhs, 1 crore of rupees, and 1 crore of rupees
security
since
deposit,
that time
41 lakhs something.
had 2000
41 lakh
and 41 lakhs on okay, well, from the since 2008 they are holding on to the money. Kindly my lord, calculate the interest on that. It will be my lord, more than triple.
Triple.
And my lord,
Three
some
times.
kind of a reason should have been given. My lord, therefore, my lord, I am, my lord, making my submission twofold. First is, there the respondents are, my lord, the government body. Well, they are, my lord, Article 12. Yes,
comes.
Article 12, my lord, authority. Therefore, they cannot, my lord, in dealing with the public, their activities can never be arbitrary. Each of their action has to be, my lord, supported by reasons. And number 3, if you do not, if you are affecting my civil right, namely forfeiting an amount of money, you must give reasons. So, my lord, 3 things. First, you are an authority who cannot act arbitrarily. You act arbitrarily. What is arbitrariness? Arbitrariness is, my lord, doing an act without being backed by reason.
Yes.
Here, there is no reason given as to why 50 lakhs of rupees has been forfeited. Number 1. Number 2, this is also an important aspect of the matter. Each action of yours should be justified by reason. You have not given any reason. You have just forfeited the amount of money. Today I forfeit the amount of money without showing, my lord, that there is any financial default on the.
Even at the time of cancellation of MOU, they have not given such reasons.
Absolutely.
They have given such different reason in affidavit in opposition.
That they cannot do. My lord, I have got the authorities on that. That if you do not speak out when it was required of you to speak out, then you cannot justify your action by subsequent reasons given by this. Mohinder Singh Gill's case has very, well, if I may just at this stage place this particular judgment. Tomar kache copy ache? Your Lordship, my lord, I shall just indicate to your Lordship that particular paragraph. In the inimitable language of Mrs. Krishna Iyer, this particular judgment was given 1978, 1 Supreme Court cases, page 405. This is a very lengthy judgment. 2 paragraphs I am going to place before your Lordship now. First is, my lord, 1978, 1 Supreme Court cases, page 405. My lord, first paragraph, I shall start off with a paragraph which is, my lord, down below in the judgment itself. Kindly come to paragraph 56. It's a very lengthy judgment, and it's one of the locus classicus delivered by Mr. Krishna Iyer. Kindly, my lord, come to paragraph 56.
Yes.
Normally, natural justice involves the irritating inconvenience for men in authority of having to hear both sides, since notice and opportunity are its very marrow. And this principle is so integral to good government. The onus is on him who urges exclusion to make out why. Lord Denning expressed the paramount policy consideration behind the rule of public law while dealing with the nemo judex aspect. With the expressiveness, then within court, justice must be rooted in confidence, and the confidence is destroyed when the right-minded people go away thinking the judge was wrong, judge was biased.
Yes.
We may adapt it to odi alteram partem situation by the altered statement, justice must be felt to be just by the community if democratic legality is to animate the rule of law. And if the invisible audience sees a man's case disposed of unheard, a chorus of no confidence will be heard to say, that man had no chance to defend his stance. That is why Lord Justice Tucker, in Russell versus Duke of Norfolk, emphasized that whatever standard of natural justice is adopted, one essential is that the person concerned should have a reasonable opportunity of presenting his case. What is reasonable is in given circumstances is in the domain of practicability, not formalized rigidity. Lord Upjohn in Fernando observed that while great urgency may rightly limit such opportunity timelessly, perhaps severely, there can never be a denial of that opportunity if the principle of natural justice are applicable. It is in untenable heresy, in our view, to lockjaw the victim or act behind the back of attempting invocation of urgency, unless the clearest case of public injury flowing from the least delay is self-evident. Even in such cases, a remedial hearing, as soon as urgent action has been taken, is the next best. Our objection is not to circumscription dictated by circumstances, but to annihilation of an easy escape from benign, albeit inconvenient obligation. The procedural precondition of fair hearing, however minimal, even post-decisional, has relevance to the administrative and judicial gentlemanliness. The Election Commission is an institution. I am not troubling your lordship. Then, my lord, your lordship will please to see. Your lordship kindly comes to this observation, the last paragraph on that page. Lord Denning's observation, which has been quoted here in the case of Silver and Yard. Kindly, my lord, turn over the page. The fundamental rule. Your lordship has got that?
Yes, yes.
The fundamental rule is that if a person may be subjected to pains or penalties, or be exposed to prosecution or proceedings, or deprived of remedies or redress, or in some way adversely affected by the investigation and report, then he should be told the case made against him and be afforded a fair opportunity of answering it. The investigation body is, however, the master of its own procedure. It need not hold a hearing. It can do everything in writing. It need not allow lawyers. It need not put every detail of the case against a man. Suffice it if broad grounds are given. It need not name its informants. It can give the substance only. Moreover, it need not do everything itself. It can employ secretaries and assistants to do all the preliminary work and leave much to them. But in the end, and this is the important thing, in the end, the investigating body itself must come to its own decision and make its own report. Therefore, my lord, what it says is this, that if a person is being inflicted with a civil consequence, he must be first of all given a hearing. He must be told that this is the reason why it is being done. He must be asked to explain his conduct, and thereafter the person who is giving a hearing must give a reason as to why he has come to the conclusion. If that doesn't happen, then, my lord, there is a violation of the principles of natural justice. In our case, kindly note this, there is a provision that if there is a financial loss, you can forfeit this. First thing, I should have been given a notice, given reasons.
There
as
is no condition of forfeiture. There is condition of adjustment.
Adjustment. That,
They
my lord,
can only adjust.
Therefore, my lord, first of all, they will have to quantify the amount of loss.
Yes.
And then they will have to say that, look, you have deposited 50 lakhs. After
Here
quantifying the
question
loss,
of loss does not arise.
nothing has been said.
Question of default, how much money you have defaulted in in the premium
Lordship,
of the insurance policy
no, well, I am
or terms
just-
and conditions.
I am looking into the language of this about a paragraph about cooler paragraph. That particular clause, kindly see the clause is very financial
Very
default.
clear, very clear. That was,
Financial default.
no,
Well,
it is, no interest shall be payable on the deposited amount.
Yes. Then
Insurer will have the right to adjust this deposit amount for any financial default.
default.
What
So-
does it mean? Financial default.
May I explain to your lordship what it means? It means two things. Number one, there has to be a default. You will have to point out that this is the default A, B, and C default you have committed. That is not good enough. You will have to also show that by reason of the default, they have suffered a loss which they are entitled to adjust against this money. So, my lord, I am reading this financial default, my lord. It has got two elements. First is there has to be some kind of a default first of all, and by reason of the default, there has to be some kind of a loss.
Is there
Otherwise,
any definition mentioned in the MOU regarding default?
no, my lord, I do not think so. So I shall check it up, but my lord, so far as I recall, there is none. Financial default, my lord, has to be, my lord, there has to be some kind of a default on the part of the insured and, my lord, consequent loss. Otherwise, my lord, there cannot be a financial default.
No, that policy was regarding group medical policy issued by GMSS,
Right.
GMSC Limited by NIC.
Yes.
So only there is a policy terms.
Correct.
Some premium should be paid.
Yes.
What is the implication of financial default then?
Well, I thought that the respondent will come out with some kind of an explanation as to what I did, which caused them to forfeit this 50 lakhs of rupees. In 50 lakhs here, 50 lakhs there. Well,
Because they have issued insurance policy in group.
yes,
Suppose today 50 persons are there.
yes,
Tomorrow it may raise 250.
correct.
You pay the insurance premium.
I have to, if I
You
do
have
not,
to pay the
yes,
premium.
yes, of course, in advance I'll have to pay.
And even if you fail to pay
Then policy will,
then that money can be adjusted.
but if I fail to pay, no policy will be issued. They will not issue the
But
policy.
this is a group insurance, so they cannot cancel the insurance policy.
Just
They
like
will
that.
adjust the money from the security deposited by you.
Yes, quite.
That is the condition. If suppose in between you fail to pay a premium, then they can adjust that money so that benefit can be rendered to the insurer.
Therefore, my lord, what was required of them? I am just questioning myself what was required of them. What was required of them was this: they will have to identify that in respect of X, you have failed to pay the premium. Therefore, I am constrained to adjust that amount of money against the deposit which you have made to me.
Yes.
This has to come on record. Well,
Is
and
there any insurance policy you have annexed in your writ petition?
not
Insurance
really.
policy.
No, I have not.
You did not annex any policy.
No, respondent's affidavit, kindly see.
Where is that?
Yes, your lordship kindly sees that. 84, 85, 88. পরে আসছে এখানে কি কি করতে পারছো কিছু হ্যাঁ পেজ 88 দেখো
certify that as per the proposal and
এটা কার ফেভারে
Ahmed Ali Mohammed.
My lord, kindly come to page 88. I can read that, my lord. It is in respect of Arshad Ali Mondal, one of the individual proposer.
Prior to that, you come to please page
আমি পড়তে পারবো না।
come to 78.
78. Yes, madam.
But this is insured is late Devasri De.
কোনটা 78 না না ইনশোর্ট না ইংরেজি লেখা রয়েছে।
You come to 74.
74. Yes, ma'am.
Dwarka
Your lordship means
Prasad Rao,
this is to certify that.
as per the proposal and declaration submitted by the company and subject terms and condition, exclusions, definition of group Janta personal accident insurance policy of the company
It is a personal accident insurance policy.
in favor of the Dwarika person.
Dwarka Prasad something. Shaw. Dwarka Prasad Shaw. So individual accident policy issued by National Insurance Company in favor of one individual. And the name of the nominee is also there mentioned.
Gita Sao,
And the amount insured is 2 lakhs.
2 lakhs. And expiring of the insurance policy was 2016.
So, my lord, these insurance policies have been issued in individual names. And individual persons.
Actually, premium was paid by the petitioner.
Through the
After collection of the
yes. After
insured.
collection from the insured individual.
That's why they have
This amount of
keep the security amount and the 50 lakhs, 50 lakhs.
so that if there is any default, they will be entitled to adjust it.
Yes. So that the insurance policy can be continued and no one can deprive due to your act.
Right.
That's why they have taken.
85 এ পুরো টার্মস কন্ডিশনস গুলো আছে প্রত্যেকটা পলিসির সাথে টার্মস কন্ডিশনস 85
And if your lordship can read it, my lord, at page 85, the terms and conditions are there.
So anything more you have to submit?
Yes, well, I am submitting to your lordship, therefore, your lordship will kindly come to your lordship will therefore, my lord, my first submission is this, that when they are, my lord, cancelling the when they are saying that I am not going to when I am asking for refund of this amount of money and they are refusing to refund it, they did not give any reason as to why they did not. They would not. Number one. Number two, before, my lord, forfeiting this amount of money, I should have been given a hearing, which they did not. This is the second violation of the principles of natural justice. Third is, no reason had been given in the letter itself by which they forfeited the amount. Now, what they are seeking to do, they are seeking to justify by way of an affidavit as to why they did not pay.
Entire amount has been forfeited.
Yes. Why that's
You are not entitled even a single rupee.
Yes, that's right.
Also, they do not demand more money from you.
No. They are just want to sit on my money without returning it to me, without giving reason. But what I am on is this is my third point I am making. I am submitting to your lordship that when they did not give the reason as to why they forfeited it, in the letter itself, they cannot justify the forfeiture by way of an affidavit. Kindly, my lord, come to para 8 of this judgment of Krishna Iyer.
Yes.
Para 8. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observation of Mrs. Bose in Govardhan Bhanji. I think, my lord, Mrs. Vivian Bose. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant, or of what was in his mind, or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed, and must be construed objectively with reference to the language used in the order itself. Then, my lord, orders are not like old wine becoming better as they grow older. Typical, my lord, Krishna Iyer. This is a very lovely line. Orders are not like old wine becoming better as they grow older. Now, my lord, my submission is this, my lord, in the facts of this instant case, there had been so many infirmities that in a writ petition, well, I tell you, lordship, very frankly, when I first got the brief, I had my reservations as to whether a suit should have been filed for recovery of this money amount. But then, my lord, I looked up the decisions. I found that Supreme Court and our High Court had uniformly said, particularly in the recent times, I should not say recent times, 1978, my lord, Justice Krishna Iyer had already pronounced. But now, my lord, it has become much more, my lord, clear that even when, my lord, a public authority discharging public duty, exposing itself to, my lord, the public requirement,
They must be fair.
There must be fair and there should be lack of arbitrariness. The people should not be.
Public is involved, so
Yes.
faith of the public will be
And, my lord,
an stake.
the issue is this, the principle is this, that the public should not be entitled to charge a public authority with arbitrariness. If you are arbitrary, then how can you rule the persons who are your subjects? This is the principle, my lord, I find that throughout this. My lord, kindly take one of these judgments, which is much more recent judgment, reported in 2004, 3 Supreme Court cases. Page 553. ABL International and Export. One copy to the Chilo. Lordship will please to take this judgment. Here, this very question arose, that as to whether the maintainability, with regard to maintainability of a writ petition in respect of a disputed question of fact. Kindly, my lord, take a few of the paragraphs, if I may just indicate to your lordship. Lordship will please to come to copy in a Supreme Court case copy. Kindly give me 1 second, my lord. I always feel lost, my lord, in this online reportings. My lord,
27 paragraph.
I'll just indicate to your lordship.
Paragraph 10, 23, 25.
No. Yes, page. Your lordship will please to come to, kindly come to para 21.
21, yes.
Kindly come to para 20. Here, my lord, VST Industries
versus
The-
work.
Para 20. The learned counsel for the respondent then placed reliance on a judgment of this court in the case of VST International. In that case, this court held, and then quotation. In Andi Mukta case, this is Andi Mukti Morcha, this court examined the various aspects and the distinction between an authority and a person, and after analyzing of the decisions referred in that regard, came to the conclusion that it is only in the circumstances when the authority or the person performs a public function or discharge a public duty that Article 226 of the Constitution can be invoked. In the present case, the appellant is engaged in the manufacture and sale of cigarettes. Manufacture and sale of cigarettes will not involve any public function. Then, placing reliance on the observations of this court in the said case, the learned counsel contended, unless the action challenged in the writ petition pertains to the discharge of a public function or a public duty by an authority, the courts will not entertain a writ petition which does not involve the performance of the said public function or public duty. Then after saying that, we do not think, kindly come paragraph 22, that the above judgment in VST International supports the argument of the learned counsel on the question of maintainability of the present writ petition. It is to be noted that VST International Industries, against whom the writ petition was filed, was not a state or an instrumentality of a state as contemplated under Article 12 of the Constitution. Hence, in the normal courts, no writ would have been issued against the said industry. But it was the contention of the writ petitioner in that case that the said industry was obligated under the statute concerned to perform certain public functions. Failure to do so would give rise to a complaint under Article 227 against a private body. While considering such argument, this court held that when an authority has to perform public function or a public duty, if there is a failure, a writ petition under Article 226 of the Constitution is maintainable. And then, my lord, your lordship will please to come to paragraph. Kindly come to para 25. A contention was raised that it was a money claim. Why should the writ court entertain the petition? Kindly see what it says. The learned
Here
counsel.
involve private company, but in this case, he is not a private.
No. It's a government body.
Government body.
Yeah, government undertaking. Yes.
Here, the public function or a public duty.
Right.
Even if the private company does public function or public duty,
Then, my lord,
will
writ will lie. Because Article 226 language is that. Then, my lord, kindly come to para 25. The learned counsel for the respondent then contended that though the principal prayer in the writ petition is for quashing the letter of repudiation by the first respondent, in fact, the writ petition is one for a money claim. My lord, similar argument. Kindly see, my lord, if I may read it again. Learned counsel for the respondent then contended that though the principal prayer in the writ petition is for quashing the letter of repudiation, I am also, my lord, asking for quashing of that by the first respondent. In fact, the writ petition is one for money claim, which cannot be granted in a writ petition under Article 226 of the Constitution. In our opinion, this argument of the learned counsel also cannot be accepted in its absolute terms. The court in the case of UP pollution control, while dealing with the question of refund of money in a writ petition, after discussing the earlier case law on this subject, held that para 12 has been quoted. In the para extracted above, in a similar situation as arising in the present case relating to the very question of refund, while answering the question affirmatively, this court pointed out that the courts have made distinction between those cases where a claimant approached the High Court seeking relief of obtaining refund only, and those where the refund was sought as a consequent relief after striking down the order of assessment, etc. In these cases also, the claims made for refund of the writ petitioner, refund in the writ petitions, were consequent upon declaration of law made by the court. Hence, the High Courts committed no error in entertaining the writ petition. Then, my lord, your lordship will be kindly, my lord, come to para 26. Therefore, this is the conclusion. This objection must also fail because in a given case, it is open to the writ court to give such monetary relief also. From the above discussion, then para 27 is the sum up. From the above discussion of ours, the following legal principles emerge as to the maintainability of the writ petition. A. In an appropriate case, a writ petition as against the state or instrumentality of a state arising out of contractual obligation is maintainable. B. Merely because some disputed questions of fact arise for consideration, same cannot be a ground to refuse to entertain a writ petition in all cases as a matter of rule. C. A writ petition involving consequent relief of monetary claim is also maintainable. So, my lord, I am, my lord, relying upon this judgment very strongly in support of my contention that this particular writ petition is maintainable and the court is entitled to grant the relief which I am seeking in this case. I am questioning, my lord, the arbitrary action of a government body. I say that it is arbitrary because, first of all, you did not give any reason in the order that you have passed. Secondly, you did not give a hearing to me before you purported to forfeit this amount of money. And thirdly, the order that you have passed did not contain any reason at all. So arbitrary from all points of view. So therefore, my lord, I am submitting to your lordship, and I do not want to, my lord, there are numerous judgments thereafter also, my lord, following this particular. If necessary, I shall give your lordship.
Not required.
If necessary, my lord, therefore, my lord, I submit to your lordship that in the facts and circumstances of the case, my lord, an order should be passed in my client's favor. These are my respective submissions.
Yes. There is no affidavit in opposition in the record. An order was also passed by the coordinate bench in the year 2023. Apart from that, there is nothing.
Lordship, if my learned friend agrees, then we can reconstruct that part only.
Yes, you can give me a copy.
I have given a copy, of course, but you can.
So,
We will reconstruct. If you require, we will reaffirm and give it to your lordship, or we can. The copy which has been given, lordship can take formally on the record. Another copy taking.
so today you will start.
Yes, lordship, I will. Lordship, the very short point which we will try to demonstrate before your lordship is on the 3 point. Lordship, the last point that our senior has placed before your lordship is writ is maintainable since my client, being a government body, has acted arbitrarily. And second point he heavily relied upon, that I was on a public function and duty. So the 2 points to maintain this writ has to be satisfied. I am completely agreeable with my learned senior friend. No quarrel on the law that if I am doing a public function, then this writ is maintained. In fact, we will not look into the prayer whether the money has been claimed or money has not been. Because even the claim of money is a consequential relief to failure of my duty to discharge a public function. So first, we have to see in the writ petition from the 4 corners whether there is a public function at all involved in this writ. And the second thing we have to bear in mind, that I am under obligation for the purpose of public function to pass a reason order maintaining all natural justice. Like if an order is being passed by the assessing officer in income tax or any other authority, so lordship, that order can be quashed. If money deposited pursuant to order can be claimed back, we have to see that order, whether that order has been passed by observing natural justice.
First of all, you give me a question, my answer, whether you are come under the state or not under Article 12.
Yes, true. Article 12, there is no quarrel. I was
My
under
next-
Article 12. Lordship, I'm just under Article 12. Lordship, I'm a state under Article 12. Whether the state was doing what function? State has got two obligations. State has got two wings. One is the administrative wing, like my controlling ministry. I'm under Ministry of Finance. So that is controlling ministry. It's a purely administrative function. There is no trading. And the trading are being done of the government units by its subsidiaries. Like for the purpose of the insurance, we have 4 insurance companies. Of course, my regulating body is IRDA, but then I am under the ministry. Licensing body is this. Similarly, banks, licensing body is RBI, but under the ministry.
So any dispute if arise between your company and private individual,
Yes. Lordship, then all my act.
REIT will lie.
No, that is the point I am trying to make before you. When it is a pure governmental ministerial function, if it is a ministerial function, then REIT. If it is a contractual and a commercial function, then no rate. Lordship, kindly see a government PWD floating tender. As long as the tender clause dispute, REIT. Moment enters into the tender, then Lordship, either arbitration clause or a commercial.
And work done,
Money not paid.
not paid.
Then also, unless there is an admitted claim, there has to be a tender floated, money done, then Lordship, admission there that you are supposed to get this, and then it's a ministerial function. Why not discharging the money?
So in any contract, there should be a disputed question of fact.
No, Lordship, the writ court, that's what I'm saying. When it is, kindly see the difference. When tender done, participated, successful, work done, but Lordship, there is no admission that I will pay you. Can court interfere that? Court will not. But in a case where admission is also made that yes, you are entitled to get this money, then Lordship, the contractual part goes. Release of the money by a government department.
In tender matter, you are issuing a work done certificate or satisfactory certificate.
Then also it will not lie. Then a step ahead, after issuing completion certificate or satisfactory certificate, then I say yes, your final bill is ₹10. You will get ₹10. And then I sit tight by not releasing ₹10.
Yes, that is the
Moment I sit tight.
that is the point here.
Yes.
Now,
Moment
in this case, what is the terms and condition of policy? Now,
I'm coming to. Let me
please give me the background of the group insurance.
coming.
And what is the responsibility of the petitioner?
Lordship, I'm coming. So, Lordship, the REIT will lie in the earlier instances which we are giving. When I admit that this is the money, then I'm not releasing the money. That means not releasing the money and admitting the money. After admission of the money to be payable, not releasing the money is the ministerial job. Then the all disputed question behind or adjudicatory right behind goes. So then purely administrative function, release of the money. If I am not doing, then mandamus will be upon me to really give a direction to release the money. Lordship has, in the morning, Lordship has heard a tender matter where Lordship passed an order that directing the appellant to release the money. Lordship has just heard in the morning. So Lordship, there has to be admission. When there is an admission that I will pay you money, then Lordship, someone cannot sit tight on.
In the MOU, you have not admitted that they have deposited 1 crore rupees,
Lordship,
50 lakhs and 50
Lordship,
lakhs. That is not admission.
Admission. Even if I am not
Admission.
written in the MOU, if the money received.
Now, what is the condition of that deposit?
Lordship, why I have taken the deposit first?
Yes. And
Lordship.
without bearing any interest. Very important point.
Lordship.
You have taken a security, but without any interest.
Yeah, I bow down before your Lordship, the security. Security is for what? Is it defined in the entire agreement? That means security is for what? That means there is a chance.
This is not a security. Security deposit was different, 41 lakh something. This deposit is only for adjustment if somebody default in payment of money.
Lordship, who will default? I put this question to
The
myself.
petitioner.
Right.
If suppose petitioner failed to pay one installment or two installment, the person who is insured should not be deprived of his own
Right.
action.
Because once he has taken,
Because he has taken
he is the
responsibility.
beneficiary.
He has taken a responsibility of 50 or 200 or 200 or 300 persons. So if he default, why they will suffer?
So I will adjust it from that.
So you have taken a security, you have taken
I
a
will
money and kept without giving any interest.
Now, Lordship, what is the case there?
Now question here, you have issued the group insurance.
True.
Either 50 or 20 or 200, whatever may be the.
Let's take one instance. We will take one instance.
One instance.
Lordship.
Suppose
Lordship,
you have given a insurance policy for 1 year.
yes.
They have paid a premium. Second year he did not pay, or petitioner did not pay.
Deduct from the main source, which is deposited with money, and I will continue this.
Continue. That policy will continue for another 1 year. Similarly, third year he did not pay, it will be adjusted.
Keep on. Yes, sir.
And entire money adjusted.
True, Lordship.
Then insurance policy will be not extended.
No, I cannot. I have
because
to continue.
50 lakhs is only the money you can adjust.
Lordship,
After that,
then also,
what would happen?
insurance law is different.
Forever insurance policy will be issued from
Lordship,
the company?
Lordship, that's what I'm saying.
No, never. You cannot.
If the money is exhausted, I cannot.
Yes, that's why I am asking. After adjust of money 1 crore, you will not extend. That is the terms and condition. Now you have issued 50 insurance policy.
When Lordship is thinking in this proposition, Lordship
and
another
ultimately, whatever may be the reason, you have cancelled the MOU.
No, not cancel. Just add another. A man is supposed to get a insurance coverage of rupees 10. See, now he has given an insurance coverage of rupees 30. When through him, because I am not purchasing, I am not selling, I have given it to him. He is selling, he is determining everything. Now he has given someone, instead of ₹5,
he is helping you because he is just like a middleman.
No,
because you cannot go individual 2,000 people. You selected one person, you come ahead. I will issue a group insurance.
For the agency, Lordship, if he wants to take it, no, this is
middleman, just
no.
As a middleman. It is not an agency. They are only rendering their service for the benefit of the members, club members.
Lordship.
They are the club members.
So, Lordship.
And for the benefit of club members, they decided, okay, we decide tomorrow that we will insure my all members. And you also agree. You agree and prepared a memorandum of understanding, signed. And you have issued the insurance policy. What is the terms and condition of insurance policy?
No, Lordship.
Medical claim.
No, Lordship, that is accidental claim, medical claim. Lordship. No, this is
whatever may be.
No, this will be this. There is another issue. Now, Lordship, kindly come to the sum issue. Lordship, kindly turn to page. Now, এখন idea দেখি। এখন আগে factual search চলছে। Minor creation factual.
Only I want to know what is the
breach
condition. What is the condition?
I will show one breach first. Lordship, kindly turn to pay, my affidavit in opposition, page 30. Page 30.
35.
31, Lordship of Law. Lordship, kindly come to column 5. Sum assured.
That is 30,
এইটা পড়েছি
35.
পড়া যাচ্ছে না অমনি না এরকম ভাবে পড়ুন
Which page you are referring?
5A
Page number?
page number 31. My affidavit in opposition.
31 perhaps has got hidden, my lord, in the corner.
Yes, 31.
হ্যাঁ
Yes.
The sum assured for table 3, Lordship got it? Sum assured for table 3 must not exceed.
You are personal accident insurance individual that you are
Personal
undertaking.
accident individual, then Lordship on the right hand side, sum assured.
Sum
column
assured, yes, 5.
Kindly read A.
Hmm.
The sum assured for the table 3 must not exceed 24 times the monthly income from direct employment of the insured. Income will not include bank interest, deposit, pension, profit, such and such from any other sources. Lordship has got it. So 24 times. Now Lordship kindly turn to page. Now kindly turn to page 88 of the opposition.
Where is the table 3?
Lordship, I will come. I will come.
Which paragraph you are referring?
Page 88. Now Lordship, can you come to the page
88.
Yes. Page 88. Lordship has got.
Yes, 88.
Lordship, kindly see this man,
Arshad Ali Malla.
Arshad Ali Mullah, his sum assured is 5 lakh. Lordship. Lordship has got it. Now Lordship, kindly turn to page 9.
Page
9.
90.
Yes, 90.
When the declaration we found, Brickfield for a long time serving his service well, he was paid 4,000 per month by me. Lordship has got it. Now 4,000 per month into 24 times will become 96. And now he has made a sum assured of 5 lakh. Just kindly see. So Lordship, then the difference of the premium will come from where? I have issued it on the good faith. I'm just giving you one instances.
Yes, monthly income.
So Lordship, monthly income of
Must
24
not exceed
times.
24 times. Yes.
Lordship, then 24 into 4,000 kind 96,000. And but his sum assured from page 88 I am showing is 5 lakh. So now Lordship, there is a difference of 4 lakh 4,000.
Before issuing insurance policy, you did not verify.
How can I?
Why not?
Lordship, when he coming to the
Why not you will verify?
kindly see. Kindly see. Kindly see, kindly date, kindly see the signature. Lordship, kindly see.
Insurance policy will issue without verifying. Huh?
Yes, yes. Lordship, kindly see the member has to be, suppose I am a member of the bar or not. Bar is taking a insurance. My name has been forwarded.
Suppose I am suffered by a disease. I apply for a life insurance.
Lordship, life and mediclaim will be
1 crore rupees.
Lordship, life and mediclaim will be different.
Even medical. I am suffering from many diseases. Can you issue a mediclaim?
I will not.
You cannot issue.
Only one I can issue, that is accidental. Accidental claim is always covered. Whoever it is, fixed accidental claim, like even if I am a terminal suffering from a terminal
At the time of receiving money, will not verify, and at the time of payment, you will verify. That is your duty. That is the public duty.
And whatever
You are fair with the public.
and someone will be unfair with me at the time of taking it, And then he will expect me to fare, and then he will put the burden on me. Lordship, can you see what are the disputes I am trying to project before your Lordship? Now, Lordship, this is then Lordship again come to
No,
page.
even if I accept your argument,
Yes.
even if I accept your argument, did you inform them in your reply?
Lordship, I will take your Lordship slowly to the depth of the fact. I'm just showing the tree. Now, Lordship, I will show this all suppressions I cannot unearth unless the claim comes to me.
That's why I am asking whenever they have given a reply, whether you have disclosed that.
Lordship, and I will take your Lordship.
Why they will come to the court?
Can you see why usually in an insurance claim or in an insurance policy, Lordship will find only one signature of the issuing authority. Lordship will never find the signature of TPA.
It will take some time. No?
Now,
Yes, Mr. Banerjee.
She has a fixed matter.
2:30.
তুমি আজকে 2:30 না কালকে 2:30?
Your Lordship, that regularization, that advertisement part, I'm being, the other side is the Advocate General, Your Lordship. It's extremely urgent with regard to the scope of advertising.
Other side is there.
Lordship, yes.
He is on his legs.
He is in leg. So
Lordship, there was urgency and it was fixed in the presence of the learned age.
why you have not mentioned at 2:30? You should have at least informed. Now he is engaged in another court.
Lordship, it will take us only 10 minutes.
No, Lordship, it will take more.
It will take us only 10 minutes. Only with regard to
Can you
advertising.
inform Advocate General if he will available? Then I will take up at 4.
Okay.
Other matter release.
Other matters are really fine.
Yes.
Now, Lordship, can you see? Usually, Lordship will see in any policy, whatever policy we have, my car policy, my house policy, my health policy, Lordship will never see that it is signed by a agent. Under section 230 of the Contract Act, if an agent is a disclosed agent, neither he need to be sued nor his name to be there, he is only disclosed. But Lordship, when Lordship will find it's almost like in this case, why the second phase of it is Lordship there, that IRDA also interfered in the matter. Why? It has not become a agent of mine. A club cannot become my agent.
That's why the MOU was cancelled as per direction of the IRD.
So Lordship, he cannot be my agent. Then who is me? He is my client. And his member are to be certified by him. Like when I take a group health in health policy in Bar Association, the Bar Association take the responsibility of noting, yes, he is an advocate. Yes, he is a member of this bar. If I am a member of some other bar, I will not be. Suppose I am an advocate, but I am not member of this bar. Then, Lordship, I will not be entitled. Then who will verify? Will that the insurance company verify with my bar directory that he has Mr. Banerjee, such and such Banerjee?
Even if I accept your submission that they have not disclosed properly, they have suppressed, they have made a practice.
Lordship, in the insurance, Lordship, in the
Now,
insurance claim,
now the question
at most,
here question is regarding the money deposited by them only for adjustment, not for any other purpose, not for any forfeiture clause. That you
he wants
deposit,
my account. He
you
wants my account.
deposit. If terms and condition, if you violate, entire money will be forfeited. That is not the MOU. from the MOU, can you show me a single terms and condition that if any terms and condition violated by them, the entire money will be forfeited? Number one. Number two, even if there is a condition that if some money will be defaulted, that money will be adjusted.
So the accounts has to be given. Basically, he is wanting
Yes.
a degree on
Now,
account.
now you have rightly come to the point.
He wants a degree on account.
Now you have come to the right point.
He
Now,
wants a-
what is your demand? Without disclosing, can you forfeit the amount? Here is the point. Now, this court can decide on that issue.
True.
That is not the disputed question of fact. Until and unless,
What is the
until and unless you give a amount, that how much money you want to adjust. If you give an amount that 2 crores should be adjusted, then court cannot enter into a disputed question of fact.
I bowed on the bed. Now, kindly, Lordship, kindly see what is the lease in this writ. My action of 2006. Please understand, Lordship, this is 2006 action is being called upon to charge. I have to see the writ as it is. We are thinking as if everything ended in 2006. But the policy continued till 2019, 15 years policy.
No, that is not the question here, whether policy was valid or invalid. This is not the dispute here.
No, that's the reason why.
Here dispute is only with regard to the money you have taken from him as a security, only for adjustment.
When I can adjust this, sir?
That is, you have to say.
No, that's what
That
I'm
you
saying.
have to say.
My adjustment, that is the point I'm trying to make out. Then, Lordship, I will elaborate. First point I said that the REIT is not maintainable because I was not discharging any ministerial function. I was being a commercial man. This was my first point. Now, my second point is the lease before your Lordship is of 2006, which they have impugned my action. Lordship, my reply to this, my action on 2006 could not have said how much money I have adjusted, how much money I have to adjust.
How can you not return?
I have so you are bound to return entire amount.
Lordship, correct. I.
If you have no demand at all, you have to return entire amount.
On that day. If suppose
entirely without any adjustment. Then when you cancel the MOU, suppose a tenant agreement, some money has been deposited with the landlord.
He is releasing and then I have to return it back. I cannot hold his money.
If 4 months rent is due, you can adjust.
True.
Or something he has done, you can adjust.
Lordship.
Ultimately, you have to return the security deposit. Similar things is here also.
True.
If you have no demand, you have to entire money you have to return.
Perfect. That should.
And root court can exercise its jurisdiction on
and force me to release it. I'm with you.
There is no disputed question of it.
Now, Lordship, can Lordship release someone's
money? From your document, even if I consider your opposition, so this court,
I will.
What is your demand?
So, Lordship can always release the money which is adjustable or payable or securable till the date of termination. On the date of, after the date of termination, if all relation between me and him ceases, I cannot hold his money.
What?
I cannot hold his money.
Yes.
I have to return.
Yes,
that's the principle of law. But kindly see, when the agreement ceases to exist, but the service promised prior to seizure will continue for another 15 years or 10 years or 11 years. Then what is my?
You have not cancelled the policy, sir.
No, I have not cancelled the policy. So what I
Yeah,
cancel,
you
I
have
cancel
not
the MOU.
withdrawn the policy.
Right, fine.
You cannot, because
Lordship,
you have already taken money.
Lordship, kindly see. That means when I have to just, I'm making a point, Lordship, then I will elaborate. That means when my service to be rendered, but money has been taken on cancellation, I cannot. This is called performance. In a case, suppose some builder or somewhere, someone makes a house. Then Lordship, party retains the money for future indemnification. Why?
No, here he will not be the person who will assure you that whether the insurer will pay or not.
So Lordship,
Because as and when you cancel his MOU,
I have to.
he will gone. Now
whoever
terms,
came under
now
my direct.
Now you became a direct to the insurer.
Lordship.
Whether they will continue.
No. Now he will become my recipient of my service direct. But the finance which I was holding, because he deposited as not his, I will take your Lordship to MOU. This money was given to me as a security deposit on behalf of the members. So Lordship, let's not connect the money with the club. The money came from the club, but for the members. Now members are continuing with me. I have to keep on giving them service. I will find the discrepancy like this. So the premium adjustment, I have to keep on doing. Kindly see, on the day he is going out, if he goes out with his member, then Lordship, the proposition said my learned senior is correct. But when he withdraws himself,
he never withdrew. You cancelled.
I cancelled or withdrew, whatever it may be. The effect
You
is seizure of the
cancel
relation.
and withdrew, two different things.
Lordship, seizure of the relation.
If he withdrew, then you had.
No, if we withdrew or I cancel, the money which is being given is not by the club, but not for the club. Money was given for the insurance holder. So insurance holder are entitled to that money for their insurance. So now whenever there is a shortfall of the premium,
so you just say for future adjustment you have kept that money.
No, I am not saying, Lordship. What I am saying is the point which I am trying to make. On the date of cessation of the relationship, what he says that on the date of cessation of the membership, you give back my money. That's not possible. That's what I said. It could be possible now because 2019. After 2019, it is possible.
So now you say how much money you have adjusted, why you have not made your plea in your opposition that yes, up to 2019 or 2026, this money should be adjusted. Now I will pay this.
Lordship,
that is not your case.
This is not a way. This is not a way which I am saying to be done. What I am saying before your Lordship is that as it is the lease on that day, because Lordship is hearing a lease.
Now, can you show me from the MOU where is the forfeiture clause?
Forfeiture clause is not required. My humble submission will be
forfeiture clause.
Lordship, forfeiture clause is not required in this type of contingent service. Because
arbitrarily, you can forfeit the money.
Lordship, it's not the question of forfeiture. It's not the question of forfeiture. I cannot. A government body will never forfeit a money because every money, even if I am not a Mr. Lalaji's company, that if I forfeit a company, I have to account for before the CAG. I have a CAG audit. I have to say how I did this money. It's from the insurance or
That
from
is
the...
that is between CAG and you.
No, Lordship, it is between everyone.
Sir is
When
not
the court is in session,
concerned about your CAG or audit report.
Lordship is not concerned, but Lordship, I cannot take someone's 1 rupee money. 1 rupee even I have to account for. That's what I'm saying.
That's why I am asking you what is your
No, Lordship,
account.
yes, sir. Lordship,
Did
kindly
not
see.
give me or you did not give the account to
No,
the
Lordship, kindly come
to the petitioner. Otherwise, they would not have come here. Because you did not give the account, that's why they came before this court.
That's it. Now, Lordship, kindly see, kindly take note of 2 issues. One is percentage. Increase in the percentage.
Please come to the terms and condition of the MOU.
Lordship, may I
Can you
formulate?
show from
I will,
any
I will.
terms and condition that any
Now,
violation
factual
or
narrative-
suppression?
Yes, Lordship, that here my learned senior friend has placed it. My senior counsel has placed it. I will also rely on that, on the clauses which I have. Lordship, another fact kindly take note. If your Lordship kindly see the number of page. Lordship, kindly turn to page 30
30.
of the opposition.
Page 30.
For the page 40. Lordship is quite eligible. Lordship will find here, left hand column here, then policy number, then Lordship
Premium.
premium, number of reported claim. Lordship, this premium, Lordship is finding as a whole, not individuals. Then Lordship, amount of the claim.
Because this is a group insurance, that's why the premium is single.
Yes, single.
Whole.
So Lordship, now the total number
It may decrease or increase as per the member.
It will decrease as per the member and as per the policy sum assured.
Policy, yes.
Because sum assured also they are changing. Because when he
Somebody-
was supposed to get 96,000, got 5 lakh. Moment I will see that, I will automatically adjust that with that sum. Now, Lordship, kindly turn to next column, the amount, number of claim. Then Lordship will find number of the claim. And then Lordship will find the ratio. At the top, Lordship will find 4%, second one. And Lordship at the bottom, Lordship will find claim ratio. Now, Lordship, kindly turn to page 48. Page
48. From 30, you did not show anything which is contrary to the MOU.
Lordship, I wanted to show the claim ratio.
Ratio may be 4%. Ratio may be
Then
380,
ultimately, the ratio gone to
381%.
381%.
There is every possibility.
Now, Lordship,
You cannot show by percentage that the policy holder cannot claim money,
No, not I mean.
or they will not
Now,
become
kindly
a
come to
yield.
page 48.
48. Yes, 48.
Discount will be 2/3% of the 66 2/3 of the tabular premium. The limit of 70% premium paid is taken as a claim premium ratio. If there is a sufficient improvement in the sum assured and CPR is less, then 70% further volume discount may be considered sympathetically by you.
All these are not relevant in this case. How all these facts are relevant with this case? Here, very simple case is involved. Very simple case is involved. They are the responsible person for their club members. You have allowed, yes, entire club member, I will issue the insurance policy, you pay the premium, you collect the premium, you pay the premium. If you do not pay, I will adjust. You have to deposit some amount rupees without interest bearing, and that amount will be adjusted time to time if you default. That is the case, simple case here. Now IRD found some anomalies between the insurance company and the person who has taken responsibility. Asked to cancel. This policy should not be continued. Group policy will not be allowed. That is the regulatory body.
Lordship, what?
And
What
asks you
was
to
not-
cancel.
Why did I hold the money? And if I have at all adjust, what is the account?
Yes.
This
That
is
is
called
the-
Lordship is.
That you have to highlight.
Alright.
If you have claimed more than 1 crore, maybe, or 20 lakhs, 80 lakhs, 75 lakhs, whatever may be,
More than
you
one,
have
we
to
will
show.
say that this was the thing. Lordship, I will.
Otherwise, it would be an admitted fact that you have received the money, you did not have any claim, then entire money you have to pay.
I will try to address myself in a shorter way. I was trying to show from the all angles that the agreement has been
Because you
flouted.
say, if you say in opposition, and you raise a different type of disputed question of fact,
Yes,
to
that will be
restrain
not-
the High Court to pass any order, genuine order, the
We
High
have
Court
made up
cannot allow this.
I will not even give a supplement. So whatever I have in my opposition, I will stick to.
দুটো এ হয়ে এসে গেছে
230 meter.
সরি ভাই তোমাকে আটকে দিলাম আমি আই এম সো সরি
Lordship, in this matter, I am appearing for respondent number 1 and 2.
But I appear for 3, 4, 5, 6,
7.
3 to 7.
3, 4, 5, 6,
7.
7.
and 7.
They have used an affidavit, Your Lordship. To that, we have used our reply.
But the Lordship may fix a date of hearing and finish of this matter.
Why it is so urgent?
Lordship, the urgency is that, Your Lordship. Lordship may very kindly takes the order date at 12th of November.
Yes.
Lordship, may I place the order? Lordship, herein, the petitioners were initially appointed as on contractual basis as dog pilot
in Holdia Dock Complex, Kolkata Port Trust, and it is contended that till date the petitioners are functioning as dock pilots. It is on contract, Lordship. Attention of this court has been drawn to an advertisement dated 24th September 2025 for filling up 3 posts of apprentice dock pilots, and it is submitting that ignoring the presence of the petitioners as dock pilot, recruitment proceedings ought not to have been initiated for appointment of other candidates on substantial basis. Now, Lordship, the next page. Prayer is made in the writ petition for issuance of mandamus in order to regularize petitioners as dock pilots in Holdia Dock Complex. Now, Lordship, this is my prayer A. Now, the next prayer, Lordship, thereafter, Mr. Datta, learned senior advocate, is representing respondent such and such and oppose the prayer based on initial engagement letter. Lordship, thereafter, coming to the bottom here, Lordship, paragraph 9, page 3.
No, you read it, paragraph 5.
Lordship, I'll place paragraph 5. Lordship, I apologize. It is submitted that by no stretch of imagination, it can be construed a right is conferred upon the petitioner to claim regularization as petitioners were engaged on contractual basis for a period of 3 years and petitioners were subsequently engaged by fresh contract. It is submitted in reference to advertisement dated 24th September 2025 that requisite qualification prescribed for submitting applications against 3 posts of apprentice dock pilot in BSc Nautical Science with 60% marks, and there is no averment made in the writ petition. That petitioners having educational qualification of BSc Nautical Science with 60% marks, according to the respondent, perhaps, petitioners do not possess the requisite qualification in terms of the said advertisement dated 24th September. Having considered the respective submissions made on behalf of the parties and taking note of the issues involved in the writ petition, court finds the issues needs to be decided on exchange of affidavits. Let affidavit in opposition be filed 4 weeks, 2 weeks. The petitioner shall be at leave to mention the matter before the appropriate bench for hearing after the time fixed hereinafter for exchange of affidavits. Now, appointments, if made in terms of the advertisement dated atho, shall abide by the result of the writ petition. Now, Lordship, what is our urgency, Your Lordship? The matter is ready for hearing, Your Lordship. The affidavits are exchanged, Your Lordship. 3 and 7 have filed their affidavit. I have filed my reply, Your Lordship. Now, in the meantime, a second advertisement comes. Lordship,
what about the 24th September 2025?
Lordship, with regard to that, Your Lordship, that perhaps the respondent 3 to 7 may indicate. What is the fate of the 24th September?
Below 24th September, below the advertisement, below in response thereto, we did not receive any application.
So you have issued a fresh.
Yes, we have issued a fresh advertisement which is open till 17th of this month. So up to 17th, below, whoever is interested to apply, they can apply.
So that should be subject to result.
Grateful, my lord. I'm only praying for this.
With respect, my lord. Number 1 is, so far as 24th September is concerned, either my learned friends' clients, their primary prayer is regularization.
Similar situation.
Either they get a regularization.
That notification, no candidate applied for, or you did not find any candidate.
Right.
You cancel that. So another advertisement you have issued for the similar post.
Right.
So similar condition can be imposed. Where is the problem?
Could I say this, Miller? Please take me to page number 51 of the writ petition.
51.
Yes. What is the first prayer?
First prayer.
The first prayer is to regularize the service of the petitioner as dock pilots in so and so, and to act in accordance with law. This is the first prayer. Kindly see the second prayer. Coming to page 52, immediately stay the operation of the advertisement dated 24th of September 2025.
And you have to amend, madam.
Lordship, I'll amend.
Without until and unless you amend the prayer,
Lordship, I'll amend.
that the prayer cannot be allowed.
Lordship, I'll amend your Lordship. Lordship, take.
Whatever you want, you do.
Lordship,
Lordship,
Lordship, that is not the thing. If Lordship, that is the scenario,
Lordship,
That
may
is the
very,
scenario.
Lordship, may very kindly appreciate.
Different. So how this court can
Lordship,
impose that condition in subsequent notifications?
Lordship, I am not challenging the subsequent notification, Your Lordship. My contention, Lordship, may very kindly appreciate. My contention is to
Subsequent
regularize.
Change of circumstances.
Lordship, the change of
You have to bring that facts to this.
Lordship, as a
petition
standing today.
Until and unless you do not bring that
Lordship,
facts.
the advertisement is part of the reply. I have already brought on record.
Reply.
Yes, we have filed a reply.
In reply, if,
Lordship, till the stage
how
of reply.
without your pleading, how reply can be considered without pleading in the writ petition?
Lordship, I can.
Whether without without pleading.
Lordship, I can
main
bring on
application,
record.
subsequent application, if you brought, that can be considered by the court.
Lordship, then kindly hears me for 2 minutes. If it is a prayer
Please
for
amend your
Lordship,
prayer
in
and
the
then come.
meantime, Lordship, I'll amend your Lordship by Monday. I'll file the amendment.
Yes, yes.
On 16th, let me come back on 17th,
The prayer
which
of
is the last
counsel
date.
appearing on behalf of the petitioner, case is adjourned.
But in that case, may it be noted that my learned friend is giving up the other prayers.
Only prayer 2. Prayer 2.
No, I will hear it out, the entire writ petition.
Lordship, I'm not pressing prayer 2.
Okay, no problem. Where is the problem? If you do not press whole prayer, what can restrain
I'm
you?
not pressing prayer 2. Prayer B. Prayer B.
So I'm hearing the whole matter.
Whenever your lordship pleases, your lordship may. But today I don't think we can conclude.
No, she can continue.
Yes,
If she wants, she can
Lordship, I am
continue up
willing
to
to.
4:30. 4:30 you can continue. Okay, no problem. Yes.
Lordship.
But in that case, may I take your lordship's leave?
Yes, yes, you
I had
my
matter
matter.
fixed at 3:30.
Your junior is there.
Lordship.
I'm great.
Because I have no other matter. I have already released the matter.
Lordship.
Lordship, may I start with the facts, Your Lordship?
Yes.
Lordship, there are the three petitioners. Now their engagements are made since the year 2012-2014. Now, Lordship, pursuant to their engagement, that engagement is on contractual basis. Now, Lordship, the basis of contractual and with regard to three of the petitioners, there is a line of difference. What is the line of difference? Now, this has come by way of an advertisement, and interview was taken, and a certificate which is required in the case of the regular dock pilots. That similar nature of certificate is issued in case of the petitioners. The relevant page numbers are page 62, 65 and
Whether
69.
that post was a vacant post or sanctioned post.
Lordship, now in the affidavit in opposition, since this what has fallen from your Lordship, I'll indicate only one paragraph from their opposition.
First contention is that they were appointed upon issuance of
Of an
notification.
advertisement. They have participated against an advertisement. But the advertisement was for
Contractual.
contractual. The advertisement indicated contractual dock pilots.
So you have not come in a backdoor.
No, Lordship, I'm grateful,
That
my
is-
lord.
that
So
is
my
what-
appointment is not illegal, not irregular, and not in the nature of a backdoor appointment.
Interview held.
Interview held.
Written. There was no written test.
Lordship, written test, your Lordship, there was also written test was also conducted.
Are you confirmed?
Lordship, written test, I'll just,
Oral was there.
Lordship, interview was there.
Next, whether sanction post was there or not.
Lordship, now coming to sanction post, Lordship, with that question, I'm not relying on my document. I'll be relying on the document of the respondent 327. Page 4, paragraph E.
Page 4 of.
Page 4 of their opposition. The opposition filed by respondents number 327.
Yes, page 4. Yes, page 4.
Page 4, paragraph E. Consequently, an administrative decision was taken that contractual officers would be engaged for the operational duties of pilotage of vessels inside the Holdia docks, as otherwise smooth functioning and working of HDC would have been compromised. Now, para F. Accordingly, 2 contractual officers were engaged under marine pilotage vessel inside HDC means Holdia dock complex in the year 2012.
You have engaged in 2012.
I am engaged in 2012 and 2014.
12 and 14. How many persons? 3.
Three of the petitioners.
So 2 persons were engaged in 12.
Lordship. One was engaged in 12 and the other 2 were
and 3.
engaged in 14.
2 and 3.
Lordship.
Yes.
Lordship, thereafter, it is pertinent to mention that the petitioners were engaged as dock pilots on contract under the Marine Operation Division of HDC Kolkata Post for an initial period of 3 years. Now this is that statement, person appointed on contract do not have a right to any post. So, the Port Authority was adequately aware that the appointments were made initially for a period of 3 years. Now, whether any sanction post was existing or not, Lordship, that is what is the pertinent question which has fallen from your Lordship. Now, with regard to that, your Lordship, it is their contentions which is making it clear that for a span of 15 years, despite vacancies were existing, required to initially selected. Yes. Page 3, paragraph D.
Yes, B.
D. In the interregnum, the Ministry of Shipping Government of India imposed embargo at the direct recruitment of the departmental officers and staff in various categories under several major ports of the country. As an effect thereof, regular departmental dockpilers could not be engaged by way of direct recruitment for a span of over 15 years. So, Lordship, this is their own document, their own statement that for a span of 15 years, they could not engage any dockpilers because of certain embargo of the ministry. So, as an alternative, a decision was taken that the existing vacancy, there were existing vacancy. This is such a nature of job which I have tried to ascertain. Here, these ships, they come inside the port and then they come inside, then they leave. Without the presence of a dock pilot, the maneuvering is next to impossible, or I should rather say it is not permissible. So to fill in those existing vacancies for over a period of 15 years, 2012, and they have decided to issue the advertisement today in 2025. So over that span of period, the contract was extended.
Time to time.
Time to time.
3 years. Every time 3 years.
3 years, 2 years, 6 months, 1 year. There was no regularity. But the person, Lordship, the break, they have tried to indicate the break is of 1 day.
1 day.
1 day. Only with the issue of the appointment letter. Whether such can be construed as a break when the certificate which was issued, page 62, I am engaged for X work.
Have you annexed all the engagement letter
Lordship, I
of
have
the
annexed.
three
I have annexed.
from 2012
Till date. They are still subsisting till, I think, March such and such. Now, Lordship, what is, instead of going into the document,
still working.
I'm still working. It is, I'll be working till there is a time span, Your Lordship. 2028.
The last date is of your agreement is for appointment.
With regard to the, there are petitioner number 1, Your Lordship, engagement letter. And this is as annexure P1.
Till when?
I'll indicate, Your Lordship. It is till, Your Lordship, till 31st March 2028. It is with regard to the petitioner number 1.
31st March
2028.
There are still time.
Lordship.
Now petitioner number 2.
Lordship, there again there is a if. There is a provision where they can be terminated also with a 1 month notice.
Okay.
Once they decide to engage the regular dock pilots, tomorrow they can easily serve us a notice on any ground. But they have never found a single complaint since 2012 till 2026, any nature of lacuna in the duty. Rather, certificates were given for providing service, for providing satisfactory service.
Satisfactory service.
Those I have all annexed.
Now petitioner number 2 till when?
2 is still the contractual extended till 31st December. The 25th March, that is at P9.
Date, please specify the date.
Lordship. P9. Lordship, 2014 জয়দীপ এটা কত? Lordship, they're all till 2028. I'll indicate the dates, your Lordship.
Okay.
Lordship. Page 82.
So all three are still working.
All are still working. Page টা বলো। কত নম্বর? Lordship, petitioner number 3 is till 31st March 2028, till the same date.
Okay.
And the second petitioner also the same. Now, Lordship, I'll place reliance on the certificate which is annexed at page 62.
Yes.
Page 62.
62
I'm only
of
placing
your writ
of
petition.
the writ petition. I'm only placing with regard to the petitioner number 1.
62.
62.
Yes, 62.
Now, this is the certificate issued by the director.
First of all, you show me the advertisement.
Lordship. The advertisement on the basis of
Appointment was given
Lordship.
initially.
Lordship, that advertisement, I have not been able to annex the same, but the contractual letter itself refers to that.
Where is that?
Lordship, that is page 56. The contractual letter itself states the initial 2012 contractual letter.
55. Engagement.
Lordship, page 56. All the documents are of similar nature in respect of the petitioners number 2 and 3.
This number 56, which
Page 56 of the
paragraph?
writ petition. Lordship, at the very first. I am directed to offer you
55 contractual engagement dated 22nd March 2022. You are referring that?
Lordship, page 56 of the writ petition.
Yes.
Lordship, this is with regard to, on the left hand side, it is written Somnath Giri. That is a petitioner number 1. I am directed to offer you a contract engagement for performing the jobs associated with the post of dock pilot on ad hoc basis under Marine Operation Division of Holdia Dock Complex, Kolkata Port Trust, for a period of 3 years. Initially, you will be placed on training for the job of dock pilots for a maximum period of 1 year. The terms and conditions of your engagement of a dock pilot will be as follows. You will be initially engaged for a period of 3 years, and on the expiry of the said period, the contractual engagement will be automatically terminated. However, on expiry of the contract, HDC, that is Holdia Dock Complex, and the Kolkata Port reserves the right to enter into a fresh contract for such period and on such terms and conditions as may be mutually agreed upon by the parties. Now, Lordship, I have been able to obtain a copy of the advertisement which is not very legible, which is part of my reply at page 115. This is the advertisement. This 2012 engagement letter is pursuant to the advertisement at page 115. Lordship, if I may be permitted to make the statement, your Lordship, they are aware of the existence of that advertisement. So if the port authorities may bring it on record on the next date.
No, this is sufficient. Where is the problem? Whether they have denied it?
Lordship, the difficulty was that
not denied it.
No. In 2012, we never had the idea that we will require the advertisement in future. So we had not kept a copy of that.
This is Xerox copy.
Lordship, upon extreme hurdle, we have been able to obtain that only one copy. It is very difficult to read.
Not, it can be read. No problem. It can be read.
Lordship,
It can be read.
Lordship,
Everything is there. Terms and conditions,
Lordship.
contractual engagement, dock pilot, under Marine Operations Division, Haldia Dock Complex. The selected candidate will be entitled to 15 days leave in a year, which may be availed. Everything is given.
Yes.
Terms and conditions is also there.
So my case is on the basis that it is on the basis of an advertisement, and Lordship subject to
Application for contractual engagement of dock pilot.
yes, 2 dock pilots on contract engagement basis.
Upper age limit was 40 years as on May 31st, 2013. Qualification is also there.
Qualification of 60% in BSc Nautical Science. All the 3 petitioners have
BSc,
not only BSc Nautical Science, 60%.
second mate, first mate or equivalent in Navy Coastal Guard. Yes. Pay is also given.
Lordship, pay was also given.
35,000.
Yeah, fixed consolidated remuneration of 25,000 per month during the training period, and thereafter 35,000.
Yes. Yes, everything is there.
Lordship, my service was required. The vacancy existed. Advertisement was floated. But after 11 years, it might be felt that today I am no more required. And nobody knows what was there in the embargo of the ministry. That is also not clear. It is only stated there was an embargo from the department of the Ministry of Shipping that you cannot take people on regular basis. So at that point of time, the petitioner was of age X. He could have applied at that time, subsequent year or the thereafter subsequent year. Today he would have been in the regular service and would have been enjoying his seniority.
Whether in 2024 the ministry has given them the green signal to appoint permanently?
Lordship, to that I am not aware. Because
whether in opposition they have mentioned that.
No. Only statements. Only their averments.
No any communications from the ministry or
no nothing.
Higher officials.
Lordship, to the best of my knowledge, the affidavit submitted by the respondents do not have a single annexure.
Okay. You prepared one note, okay?
Lordship.
Date of list.
Lordship, whatever I submitted today, Lordship, I'll prepare a note on it. Lordship, my grievance is that if tomorrow they proceed with the second advertisement, then my story, Lordship, I am not aggrieved by the advertisement.
What cannot give you the advice?
Lordship, I am not on that. Lordship, here's the matter on
before
Lordship,
engagement.
Before engagement. Oh, that is my only prayer. Until such time the matter is heard, Lordship, I may make a prayer before this honorable court. It should be ensured.
Whether any awardment made in their opposition that post was not sanctioned post anywhere in their opposition.
Lordship, they have stated that remitted again.
Next day you come with prepared.
Lordship is keeping the matter on.
When is the last date of submission?
May I make the submission? By 17th, we'll be receiving the application, 17th April.
17th April.
We will be receiving the application. Thereafter, there's a scrutiny process. Then, if required, there is an examination process.
Written examination is there.
So, Lordship, there will be some time for it to actually culminate into actual appointments. And at the moment, they are still...
How many posts you are recruiting?
What's it? That instruction I don't have. They have issued the advertisement
basis
for dock pilots.
Huh?
Dock pilots.
Dock pilot for how many posts?
How many?
Page 62 I have annexed.
You go through and tell.
I have annexed the second advertisement also.
No, how many posts they are?
Three vacancies. 3 vacancies. Post of dock pilot, 3 vacancies.
And you are 3.
I'm 3 and I'm entitled, your lordship.
Their
I'll
appointment is
satisfy.
still continuing till 2028.
Maybe. They want to regularize. আচ্ছা এটা কেটে
That
দিই
is
পুরো
not
সব।
the prayer.
Lordship may also note
So
that
may I